Hello everyone, I'm Nazarat Fatima. Welcome to LiveLaw. The Supreme Court on July 5th observed that in cases of motor accident claims, the physical disability caused due to an accident must be judged with reference to the nature of the work being done by the injured for assessing award of compensation. Let's see what the case is about and how the court dealt with it. In this case, the appellant, who was working as a gunman with Bharat Hotels, met with an accident. He was injured and his right lower limb had to be amputated, and because of the amputation, his service was terminated. He was awarded a total compensation of rupees 34,29,800, out of which rupees 30,84,800 was awarded, taking into account his functional disability at 100% with reference to his job as a gunman. Following this, the insurance company appealed against the order of the tribunal before the High Court of Delhi, and the High Court reduced the compensation by 4,92,205 rupees, taking his loss of earning capacity at 80%, even though the appellant had suffered amputation of his right lower limb. The petitioner contended that reducing the loss of earning capacity to 80% was an erroneous decision, as he had lost his right limb and its functional disability should have been taken at 100% because due to it, he was also terminated from service. Meanwhile, the respondent insurance company submitted that the tribunal had erred in calculating the compensation by the tribunal in terms of the disability certificate which was produced by the appellant, and the High Court had rectified it. It was submitted that the certificate issued by the hospital showed permanent physical disability at 85%, noting that his condition was not likely to improve. The Supreme Court set aside the order of the High Court and held that the tribunal was right in assessing his functional disability at 100%, given that he was working as a gunman and that he lost his job on account of the injuries sustained in the accident. It said, and I quote, "We find that the appellant herein was working as a gunman with Bharat Hotels Limited. On account of amputation of his right leg above the knee, he was terminated from service with effect from 31st of May 2015. It is not a matter of dispute that a person with his right leg amputated cannot perform the duty of a gunman. This is his functional disability. He was 50 years and 5 months old at the time of accident. Considering the aforesaid facts, in our view, the tribunal was right in assessing the loss of earning capacity of the appellant at 100% and assessing the compensation accordingly. The High Court was in error in reducing the loss of earning capacity to 80%, relying upon the judgment of High Court, despite there being a judgment of this court available on the issue. The Apex Court also relied upon the judgment in Mohan Soni versus Ram Avatar Tomar and others to state that any physical disability arising from an accident needs to be assessed, keeping in concern the nature of job that the injured person is performing. In this judgment, a division bench of Justice Abhay Oak and Justice Rajesh Bindal had observed, and I quote, "Any physical disability resulting from an accident has to be judged with reference to the nature of the work being performed by the person who suffered disability. The same injury suffered by two different persons may affect them in different ways. Loss of leg by a farmer or a rickshaw puller may be end of the road as far as his earning capacity is concerned. Whereas in case of the persons engaged in some kind of desk work in office, loss of leg may have lesser effect." That's all about it for today. We hope you like our content. Please like and share our videos and press the bell icon to get notifications. Meanwhile, you can also check our podcast section in which our daily court news and other sorts of stories are also covered. Thank you for watching.